Hello, everyone. We will now be joined by our panelists, Howard Manis, Barbara Visentin, and Michelle, who will lead us into our next talk on divorce, separation, and bankruptcy. I will now take a moment to introduce today's topics and then share some background on our panelists. Thank you for joining us today, Barbara and Howard. On the agenda for this presentation, we have my client just went bankrupt. What now? The role of trustees and judges, legal implications of consumer proposals versus bankruptcy, where am I, the family court or the bankruptcy court, bankruptcy and equalization of net family property, bankruptcy and support obligations, what you need to know about fraudulent conveyances, legal fees and cost orders. The panelists will also share some of their practice tips and strategies. I will now take a moment to introduce our speakers. First up, we have Barbara. Barbara is a licensed insolvency trustee and manager of operations for Hoes Mekles and Associates. With 25 plus years of experience, she offers personalized service to help people gain a fresh financial start. Barbara manages the day-to-day operations at Hoes Mekles. She is responsible for staff training, policies and procedures, and ensuring the Bankruptcy and Insolvency Act and CAIRP's standards of professional practice are incorporated into the firm's operational standards. Barbara continues to work closely with the stakeholders to resolve issues and/or concerns during the insolvency process. We have Howard. Howard is a partner and senior counsel of Manis Law. He has been practicing bankruptcy and insolvency law and commercial litigation since his call to the bar in 1993. He provides legal advice to trustees in bankruptcy, receivers, banks and other financial institutions, landlords, trade suppliers, and debtors in all aspects of insolvency law, including bankruptcy, proposals, reorganizations and restructuring, enforcement of security, and in protecting rights outside of insolvency proceedings. Our co-chair, Michelle, is back with us, and she will be guiding our talk with Barbara and Howard today. Thank you to our panelists for joining us today and sharing their expertise with us. I will now let Michelle lead us into our topic. Thanks, Michelle.
Thanks so much, Shanza, and thank you so much, Barbara and Howard, for joining us today. I am very excited about doing this topic because, as I confessed to Barbara and Howard, I've been doing this forever, but I really don't know enough about this topic. And I think this is a very important topic because it just shows up sometimes. And once this happens, you kind of need to know what's going on. So why don't we launch into our very first poll? What happens if my client or the other spouse goes bankrupt during a family law case? I think this is one of the things that family lawyers have nightmares about, Howard and Barbara. So we're looking forward to having you guys tell us a little bit about it.
Hopefully we can help with this topic at 3 o'clock on a Friday afternoon.
We're going to make it as fun and exciting as we can, that's for sure.
We will.
How are you doing today, Barbara?
Good. Today's a great day. It's Friday, so that always helps. Looking forward to the weekend.
Thank you. And I know that Barbara and Howard, you guys have put together some materials for us, so that'll be going out in the show notes as well. So thank you so much for doing that. All right.
Great to be here.
Thank you. Okay, so no one said everything stops. I think that would have been my gut reaction. Continue with all claims except property. Continue with the property claim through a trustee. 54% of people think that's the correct option. And then we've got 8% thinking that ask the family court and 23% saying lift the automatic stay to continue with your family law case. All right, guys. So what's the correct answer here?
Well, my answer would be a little bit of everything. Because each component is what often occurs. And we're going to talk about this a little bit more, but when there's a bankruptcy, there's an automatic stay of proceedings. So the first part, everything stops, is accurate, but some of the other answers are also accurate because you still need to deal with your property claims. You need to deal with your non-property claims like support, and you need to potentially lift the stay to continue your family law proceeding. So I give an A to everybody. Barb, you have anything to add to that?
No, it's true. It's a little bit of everything, and we get involved rather quickly in those matters. Obviously, it's a very emotional and stressful time for the people that are also involved on both sides. So it's nice to get a resolution going.
Howard, I wish you were my family law prof, although I did get an E in that course anyway. Why don't we jump in to my client just went bankrupt. What now? Howard, would you mind walking us through this one?
Sure. So client goes bankrupt, all of his or her assets vest in the trustee. So if I could relate this to a family law matter, the part where it most often comes into play is when there's a house involved. And both spouses are generally on title. Even if one spouse is on title and the other one isn't, the bankruptcy could have implications for sure. But assuming that both spouses are on title, then when one spouse goes bankrupt, their interest in the property vests in the trustee. So what that means is the trustee now essentially owns that 50% or whatever percentage in that house. So both sides have concerns when this happens. The bankrupt spouse, albeit less concerned because the trustee has taken over in this proceeding, the non-bankrupt spouse now has a million questions. What happens to my house? Am I forced to sell? Is someone going to take it away from me? We're going to get into all these things, but that's the major role. So when I mentioned earlier, there's a stay of proceedings and you may need to lift the stay of proceedings. That's a motion to the bankruptcy court, which we'll talk about soon, but a lot of things happen. If I'm talking to a group of lawyers, the most important question is, my client went bankrupt, how am I going to get paid? Because I still need to help with support or custody or access or any of those issues. So my quick and dirty answer is, your client who was servicing a whole bunch of loans and credit cards now no longer has to pay those. So where they were spending thousands of dollars a month on minimum payments or keeping them current or doing the best they could, they now don't have those payments, but they still have the income. So from a payment of legal fee issues, you're probably in a better position. There's more income available.
Thanks so much, Howard. So what happens, just quickly, what happens if they went bankrupt before separation? How would that be different?
I'm happy to address that, Barb.
In which aspect? The trustee still has that vested interest in the asset with it. So that would not disappear. If they were to separate afterwards, there would be more issues, I guess, with, spousal support. How did the income change? Different things that may impact the person's bankruptcy and payments to a trustee.
Thank you so much. Okay, so why don't we talk a little bit about the role of trustees and judges? Who wants to take this one? Barb, do you want to start?
I can start with the role of the trustee, and then Howard can finish off with the judges, if that's okay. So licensed insolvency trustees are federally regulated professionals. There's about 1,000 of us in Canada. We provide advice and services to individuals and businesses with debt problems. So we are there to help people make informed decisions and choices to deal with their financial difficulties. Trustees provide interested parties with full and accurate information. So if someone has filed and you are a creditor, you can give the trustee a call, ask information, become knowledgeable. They're going to give you the right answer. They're going to help guide you along the whole process as well. We're the only professionals authorized to administer government regulated insolvency proceedings for bankruptcies and consumer proposals, and allow people to discharge their debts. So the options may be the best solution for the person who has significant financial difficulties. Once a proposal or bankruptcy is filed, the trustee actually deals with the creditors directly on behalf of the bankrupt or the debtors. So in addition to unsecured creditors, you can't continue to initiate any collection, legal actions against the bankrupt or the debtor.
So if I'm talking about judges, that means we're going to court. So that could either be the family court or it could be the bankruptcy court. In most cases, spouses are involved in litigation. They're in family court. When one spouse files for bankruptcy, as I said, there's a stay of proceedings, so that family court action stops. We need to then go to the bankruptcy court for a motion to lift the stay of proceedings to allow the family court matters to continue. Those motions are routinely granted, especially in family law proceedings, because it's imperative that the non-proprietary claims be addressed, but also with respect to settling equalization, which falls within the bankruptcy, or support, which has implications in a bankruptcy or a proposal. So in either event, you're likely to get into court unless there's some kind of consent that can be arranged along with the trustee and save everybody from going to court.
Thanks so much. Okay, so what are the legal implications of consumer proposals versus bankruptcy?
So a consumer proposal is for someone who has less than $250,000 of unsecured debt. It doesn't include a principal residence, but it does consider if you have vehicles, recreational toys, different things of that nature is encompassed in that amount. Consumer proposal is usually about a 60-month period. It's a negotiating time with your creditors. Payments are made usually equally over 60 months, but sometimes they can vary. Consumer proposals are made to all your creditors. There is a stay of proceedings in place, which we've talked about. That prevents creditors from commencing or continuing any collection activity to recover a claim. Garnishments are stayed as well, so the employer can no longer deduct those from their pay. The things that are still allowed to be deducted would be your support obligations. Assets in a consumer proposal do not vest in the administrator. The debtors get to keep their assets. Creditors have 45 days to vote on a consumer proposal. It's one vote for every dollar, majority rules. So if you have 50.01% voting in favor, proposal's accepted. It's a legal binding agreement between the debtor and their creditors. Consumer proposals can be automatically annulled if a debtor misses more than 3 payments in arrears. So we have a question. Can a bankrupt lawyer accept a retainer? Would be prioritization of creditors.
So I'll just, if you don't mind, Barbara, I'll just read the question out again.
Yep, that'd be great.
Right. Can the bankrupt's lawyer accept a retainer, or would that be a prioritization of creditors? What are your thoughts on that, Barbara?
Most lawyers do obtain a retainer at the beginning as part of their trust funds, and so it would still remain in their trust funds. With it, there's usually a lot of costs associated representing someone. The retainers, I think, are usually less than what usually the cost is at the date of insolvency. Would you agree with that, Howard?
I would, and I would also add that retainer by a lawyer post-bankruptcy or post-proposal doesn't have the effect of jumping ahead of creditors, because the creditors are crystallized as of the date of the filing. So if you get retained by a bankrupt individual after bankruptcy, it's a post-bankruptcy obligation of the debtor, so it's not affected by the bankruptcy. So from lawyers in this session, there's no issue with taking a retainer, and it happens all the time. I can tell you that sometimes I get retained by an individual before they go bankrupt, but more often than not, it's after they go bankrupt or file a proposal, because that's when problems arise and they need help. The most common one is to get, when someone goes bankrupt and needs a discharge, if it's opposed, it has to go to court. Most people have no idea how to navigate through the court system. And if it's complicated issues, they retain insolvency lawyers. So to answer that question, there's no issue with that. And you don't break any rules and you don't jump the queue as far as priority. Sorry, just to supplement that, if you have an outstanding invoice pre-bankruptcy, then unfortunately you fall within the bankruptcy. There are some creative ways to get around that afterwards, but one of which might be that in order to continue retaining the individual lawyer, the client needs to have a third party pay money to cover the lawyer's previous account. But there's ways around it, but technically speaking, pre-bankruptcy debts are all frozen and all creditors are treated equal.
Thank you so much for that answer. Okay, so why don't we talk about bankruptcy then?
So a bankrupt is a person who has made an assignment in bankruptcy, or an order is made against them. And it's this legal status of the person. The stay of proceedings is in place for them as well. Same rules apply to that along with the garnishment orders. But the difference is the assets vest in the trustee. So the trustee now owns 50% of the house. There are also issues potentially with RRSPs, RESPs, windfalls, inheritances, those types of things, all vest in a trustee with it. So people do have to record income. They have to record if there's any inheritances, lottery winnings during the course of it. And the trustee has to deal with those things. So the biggest implication here would probably be an RESP and house equity and how that's going to impact the other spouse. Because usually the RESPs can be joint between the two of them. The length of the bankruptcy is going to depend on how many times the person has already been bankrupt before, as well as what their household or personal income is. There's an impact on the credit bureau for both bankruptcies and consumer proposals, but it's also dependent on the number of times the person has been bankrupt, connection with the discharge date, how long it's going to stay there, whereas in a consumer proposal, it falls off 3 years after, so it doesn't matter how many consumer proposals you've done, where bankruptcy, the timeline lengthens with each one in which you have done.
Thanks so much, guys. And a lengthy question came in. I'm just going to throw it at you, and I'm going to try to.
I just answered it, Michelle. If you want to deal with it that way, or if you want to deal with it in the open forum.
Well, would you mind actually doing it in the open forum? I'm not sure if when you answered it, if it was just to that person.
I was told on previous sessions by your firm to always do it private. So that's what I did.
So it was done privately, yes.
I'm happy to summarize the question very quickly and give the answer.
I'd appreciate it. I think it's a good one.
It was a very good question, actually. The question was that once two spouses are involved in matrimonial proceedings, it goes to court and there's a significant cost award against one spouse. That spouse then files for bankruptcy. So the question was whether this is A, permissible, and B, what the effects of discharge are. So my answer to the first part, whether this is permissible, is yes, it is, because it's a debt of the individual. Clear and simple, the court ordered that this individual needs to pay a certain amount of money in costs. We see this a lot because cost orders can be hefty, and people in family law often spend a ton of money, and often money that they don't necessarily have. So then when they get a cost award against them, it's just a double whammy. Not only did you lose, but now you owe the other side a chunk of money that you can't pay. So filing for bankruptcy or proposals in those situations happens quite often. The point about bankruptcy discharge, I mean, sure, it can be opposed by any creditor. It's not surprising that the non-bankrupt spouse may oppose the discharge, both for two reasons. One, out of spite and just to cause problems to their former spouse, but also because they spent a lot of money. The court ordered costs in their favor, and now the bankrupt spouse is trying to essentially rid themselves of that debt through the process. So if that particular spouse has good income, they might want to oppose the discharge for legitimate grounds and say that there should be a conditional order, which means that to get out of bankruptcy, the bankrupt individual needs to pay some money in order to do so. So it's not viewed negatively, and it's not necessarily a death sentence to the bankrupt, because often there's very good reasons why the person filed for bankruptcy and does not always imply financial irresponsibility. So I just argued both sides of that discharge hearing, but from either side, there are legitimate reasons, A, to oppose, or B, to get out of bankruptcy.
I think that's really helpful because let's be honest, as family lawyers, we might be on both sides of that argument.
That's right. And as insolvency lawyers, we're often on different sides of that same argument.
All right. Why don't we move on to where am I? Family court or the bankruptcy court?
So we touched on this a little bit. The bankruptcy court is usually your first instance in the event of an insolvency filing by one of the spouses. Again, the reason being that stay of proceedings we keep talking about in either a proposal or a bankruptcy. So very quickly, if an individual files a consumer proposal, which, as Barb said, is under $250,000, those are automatically approved, assuming you meet the certain tests. 98%, 99% never go to court. There are bigger proposals which are over $250,000, and spouses may be involved in those proposals as creditors, and those proposals have to go to court because they need to be approved by a judge. Generally speaking, they're granted almost automatically because all of the creditors have voted in favor in accordance with the tests in the act, but the creditors have accepted the proposal, so the court rarely intervenes. In bankruptcy, as I said, you might need a motion to lift the stay. I don't want to repeat myself, or you might end up with the bankrupt individual seeking a discharge. So a lot happens in the bankruptcy court, if any court, but again, if someone is successful in lifting the stay, you end up back in family court, often to have family court determine equalization. So the non-bankrupt spouse, if they're the recipient of an equalization payment, needs to crystallize their claim so they know what to file in the bankruptcy. The same might apply for a proposal, but usually less stringent because there may be less scrutiny of the non-bankrupt spouses or non-debtor spouses' proof of claim in a proposal. Moral of the story is try to stay out of court.
I think that's the moral of every story, except you're talking to a bunch of lawyers, so wrong crowd.
Well, we're here to settle and solve problems, right?
Thanks so much, Howard. Okay, why don't we launch into our next poll? What can happen to the matrimonial home if one spouse goes bankrupt? I am so excited to hear your answer to this. We'll just give it a minute for everyone to lock in their answers, and don't worry, it's completely anonymous, so please feel free to vote and let's see what everyone thinks.
How come one of the choices is not the non-bankrupt spouse burns down the house? That's not one of them. Or they just want
That's
to.
not an option.
They just want to.
Have you ever seen that happen? Please say no.
No.
You're just adding to my list of nightmares here, Howard.
Yes, no. Don't let that add to your nightmare.
All right, so here's the answers. Okay, so 8% think that the house is sold, 8% think that the trustee takes possession of the home, 68% think that the non-bankrupt spouse can make a deal, and 16% think other. So what's the answer?
Barb, over to you.
A lot of them are the answer. So the home can be sold. The trustee can take possession with it if they can't come to an agreement, and the non-bankrupt spouse needs to make a deal with the trustee. So any of those scenarios can happen easily. The other spouse gets the home, very rare. I don't think I've ever seen that at all. With it.
Just to add to that, what generally happens, the non-bankrupt spouse makes a deal with the trustee. If you remember, I said that the bankrupt spouse's interest vests with the trustee. The trustee doesn't want to own a house with the non-bankrupt spouse. They want to fulfill their duties and close their file. So they recover on the assets as best they can, but nobody's out generally to, kick out the non-bankrupt spouse, cause hardship to that person who already presumably has hardship. So the one takeaway to all the family law lawyers in this group is, if that happens and your client is the non-bankrupt spouse, reach out to the trustee or wait till the trustee reaches out to you or your client, but deal with the issue. The ones that ignore the trustee are the ones that end up with problems. The trustee will then register on title, so that'll cause problems. And then if the trustee is getting stonewalled, they may bring an application for partition and sale. And those are routinely granted by the courts. So you don't want to get there. You want to be in a situation where you control your destiny.
And our job is to liquidate the assets for the benefit of the creditors. So obviously we want to be able to deal with the non-bankrupt spouse, come to some sort of an agreement, figure out payment plan, whatever it's going to happen to be. That's fair and reasonable for all parties. There are, we have to look at value of the property, the mortgages against it, everything else to see what the actual equity is.
But at no time does the trustee insist generally in every last penny. So, if you get involved and make a deal with the trustee and negotiate back and forth, and it doesn't have to be 100 cents on the dollar. And it generally isn't, because a trustee doesn't want to go to court. There's costs, there's expenses, there's time delay. The trustee doesn't really want to sell the house because generally trustees don't like to displace people. If you have children, that's a factor as well. So if you take anything away from this session, is always deal with the trustee. They're not always bad people. Some are, but generally they're not. And they're not out to get anybody. They have a job to do to realize on assets and distribute them to creditors. That's all they want to do.
Thanks so much. I'm going to ask one other question. So does your answer differ if it's a consumer proposal and not a bankruptcy?
A consumer proposal, the assets don't vest in us. So what we look at in a consumer proposal is what is their equity. Consumer proposals are generally better than bankruptcy scenarios for the creditors on a return. So say there's $20,000 of equity in a home. In a consumer proposal, maybe the proposal payments will cover the $20,000 plus maybe surplus income issues so that the creditors will get a better return and the person keeps their assets.
Excellent. Thank you so much. Okay, let's move
Good
on.
question, Michelle.
Where am I? Oh, sorry, we just did that one. Let's move on to bankruptcy and equalization of NFP. Barb, do you want to go ahead and take that one?
Sure. So we'll talk about some exempt assets and claims that survive bankruptcy. RRSPs, the contributions someone makes in the 12 months prior to filing are not exempt. The exemption goes for anything that the person paid greater than 12 months within. So that would be the only little portion that we look at. RESPs don't have an exemption. with it, but there are things within the RESPs that we do have to consider. How much of it is grant, how much of it is growth, how much have they put in, what are the administration costs in order to redeem it early, different things of that nature to get an actual net value of it. But that has an implication for a non-bankrupt spouse. If they are joint on that, do they want to buy back that portion of the RESP? Are they going to allow that to be redeemed? Different things. So those are things to consider. In Ontario, we do have a Provincial Exemptions Act. So vehicles do have an exemption of $7,100, household goods of $14,000. Tillage of the soil is just over $31,000. The Ontario Executions Act has a principal residence exemption of $10,783. So the principal residence of a debtor is exempt from forced seizure, sale by any process at law or an equity of the value of the debtor's equity in the principal residence does not exceed the prescribed amount of the $10,700. But if the value of the debtor's equity in the principal residence exceeds the prescribed amount, the principal resident is subject to seizure and sale under the Act. So when we're looking at equity, different things, we're looking at the bankrupt's equity, not the total household. And the Office of the Superintendent of Bankruptcies confirmed that the prescribed amount is in reference to the debtor's share of the equity in the property, not the total equity. So if we were to take a vehicle that doesn't have any encumbrances on it, it's worth $20,000, we sell it at auction, we give the bankrupt back the first exemption amount of $7,100. If something happens within a sale of a property, the bankrupt is not entitled to the exempt amount of this $10,783 under the Ontario Executions Act. So the trustee would keep that full amount and the person wouldn't get anything back. Anything to add on exemptions, Howard, before we go on to?
No, I think you covered it all.
Okay. So claims that survive bankruptcy and consumer proposals, it's section 178 under the Bankruptcy and Insolvency Act. And it outlines a number of points. So fines and penalties imposed by the court. Speeding tickets would be one of them, parking fines, those types of things, award or damages by the court. Debt and liability for spousal and child support survive. So it's not something anybody can get out of, regardless of the situation. Debts arising out of fraud, embezzlement while in fiduciary capacity, obtaining property fraudulently. The other thing is student loans, if they've been out of school for less than 7 years, that survives. And the liability for a dividend that a creditor wouldn't have received. So if someone purposely does not add someone to an insolvency proceeding and the file is now closed, the bankrupt or the debtor would be responsible to that creditor for whatever dividend everybody else has received in it. Equalization payments are not exempt. So they are an asset and they are also a dischargeable debt.
So if I could just add, the matter that's of most interest to this group is the debts arising for spousal or child support. So in this case, the non-bankrupt spouse says, I'm owed X number of dollars. The court has already ruled on it. You make a claim in the bankruptcy. You might get a dividend, so that reduces your claim. But as Barb said, these are claims that survive the bankruptcy. So you want the bankrupt to be discharged from bankruptcy at the earliest possible moment so that you could continue to go after them for the arrears of support. Now, people might be wondering, well, how am I going to get paid? They were just bankrupt. But remember what we said at the outset. They're discharged from bankruptcy. All their debts are gone, except the debt to the non-bankrupt spouse in the normal course. And that individual is still earning the same income, presumably, but they have no debts.
Right.
So you want them discharged. So we talked before about opposing the discharge. Well, in this case, you may not want to oppose because you want them to be discharged. So all their previous debts are gone and you're the only one left standing. Something to think about.
Yeah, and along that line too, if there is a FRO agreement and FRO's taking the funds from the payroll, they're going to get that regardless going forward. And that's not going to stop either. Canada Revenue may forward all tax refunds still. Those don't get stayed either. They don't vest in the trustee if there is a FRO application in force. So the other part with this is called section 136, and 136 is just how dividends are paid. It does have a section in here for child support and spousal support as well. So if someone is owed arrears within a 12-month period prior to filing, those become a priority after trustees fees and a couple other things that we have to pay, levies to the government, but they would be paid prior to any of the unsecured loan. So the unsecured loan being credit cards, personal loans, with it, Canada Revenue debt would be included in that. So there is a priority for the 12 months leading up to the date of insolvency.
The last point I want to raise, just Barb made a statement that equalization, it falls within the bankruptcy and is discharged. But this is not something that, I mean, you lose your priority, but remember that if someone is ordered to pay equalization, it means that they have some assets that will now vest in the trustee. So give you a very quick example. If the bankrupt spouse is the sole registered owner of a house on title, that house now vests in the trustee. So whereas in a non-bankrupt situation, you as the non-bankrupt spouse would get your half of that equity. But in a bankruptcy, it gets shared with all the creditors. So not ideal for the non-bankrupt spouse, but it's not like you're getting zero. Very not ideal.
Thank you so much to both of you. Okay, let's move on to our next section. So bankruptcy and support obligation. So Barb, do you want to take this one?
Yeah, so this was part of the 136. So bankruptcy and the support, the support payments, child support and spousal support will continue to be paid. They would have the priority under 136. They're not dischargeable under section 178. With it, it also has an impact in a bankruptcy as to what the person has to pay. Bankruptcy is income driven as well as asset driven. So we do consider the person's net monthly income, and there are a few deductions that we allow which actually reduce surplus payable so that they can still afford to make those payments, especially child support and spousal support.
Thanks so much. Okay, Howard, do you have anything to add to that?
The only thing I would add is things get crystallized as at the date of bankruptcy, but the day after, those child support and spousal support obligations still continue.
Right.
Those debts don't stop. So what crystallizes at the date of bankruptcy is any arrears, but going forward, there's still the obligation on the bankrupt spouse, if they're paying, to continue to pay.
Thank
So
you.
that might be another reason why you end up in court if they stop paying.
Right.
Excellent. Okay, why don't we move on to the next topic? What you need to know about fraudulent conveyances. Howard, why don't I give you this one?
Sure. So the most common fraudulent conveyance in the context of family law and bankruptcy is either pre-separation or post-separation. The debtor, so the spouse that's going to file either a proposal or bankruptcy, will often transfer their share of the house to their other spouse. And then they go bankrupt, or they go to the trustee to make a proposal, and the trustee says, well, do you own any property? And they say, well, no, very proudly, as of today, I don't own any property. And one of the questions that has to be filled out in either proceeding is, have you transferred any property within 1 year? And most commonly, this comes up and the debtor says, yes, I did. or the trustee does a title search of the house and sees the transfer. So this is the most common, and these are easily reversible because the presumption is that it was done solely to avoid creditors. And in 99% of the times, that's true, because why else would you do it? Now, we've often seen it where it happens in a separation agreement. And so parties enter into a separation agreement 6 months before, and one spouse says to the other, as part of the agreement, I'm transferring my interest in the property to you, and signed, sealed. And that's a defense that's used when a trustee comes calling and says to the non-bankrupt spouse, hey, I need half of the house back. He said, well, we negotiated a separation agreement. I had no idea that he or she was going to file for bankruptcy. We both had very competent lawyers dealing with it, and this is a bona fide transaction. They rarely get to court because their settlements are negotiated with the trustee. But it used to be that separation agreements were treated as gospel. Well, you have a separation agreement, it was done in good faith, so we're going to uphold that. But these days, they're not as routinely upheld in the courts because people are very creative and clever and sinister. So it's not genuine bona fide reasons I wanted to give this to my ex-spouse instead of support or something like that. It's, I don't want my creditors to get this, so I'd rather give it to my ex-spouse who can stay in the house with my kids. So those need to be treated carefully. And as lawyers, if someone comes to us and says, I'm going bankrupt and I need to transfer my house to my wife because I'm meeting the trustee tomorrow and I need to do this today, it's going to be set aside very easily if it gets that far. So you may want to counsel your client accordingly that I can do this, but it likely won't work.
You get all sorts of interesting situations in family law. I haven't come across that one yet, but thank you. I'm sure it will happen at some
I'm
point.
surprised that you haven't, because we see it a lot.
Really?
Yes, and what I also see a lot is people say, well, if I divorce my spouse, will that help me in my bankruptcy? Or if we separate, because they think, well, if they're now separated, it'll change the whole landscape. But as Barb said, it's income and asset driven, not relationship driven. But a lot of people say that, if I divorce, and I'm like, but are you divorcing? Well, we could live separate and apart in the same house. Nobody comes into the house, so they won't know. And we just won't go out to, walking the dog together around the block, so nobody will know. It doesn't really help your situation, but clever.
The other thing we see a lot is people transferring assets or selling an asset. So they have an asset, a boat, something of that nature, worth maybe 40,000. They sell it to their brother for 5.
Yeah.
So now we're going after the brother for the difference. So there's a lot of different relationships within transfers of asset.
We see that one a lot.
But that doesn't really help, because if you sell an asset and you disclose to the trustee, well, I sold the asset, well, then you have cash. Whether you sold it for fair value or not, you have cash. So the trustee is going to say, well, what'd you do with the money? And the answer 99.999% of the time is, I used it on living expenses and it's gone.
Yeah.
The other 1% is, well, I went to the casino and I lost it. Both of which likely are true.
All right, why don't we go into our next poll? So this is a good one. How are loans from friends and family treated in bankruptcy? So while we're doing that, we had a question come in. The question is prospective and retroactive child and spousal support treated the same in bankruptcy? And I think we touched on it a little, but would you mind just explaining that difference?
Go ahead, Barb, that was on your topic.
Yeah, so the retroactive child support, it does have the 12 months prior to filing, has a priority under section 136. So the spouse would receive their dividends up to the point of the full amount prior to any of the unsecured creditors being paid. The prospective ones going forward, that's still a debt. It's a post-bankruptcy debt. It survives. Anything that you don't get paid on the arrears coming up to that still survive as well. The person's responsible for it. We've seen a lot of cases where the garnishment is partially for arrears on someone's pay and then partially for going forward. Those don't get decreased during the course of a bankruptcy. Those agreements stay in place as well.
Thanks so much for that. Okay, so why don't we see the results of our poll? All right, a few people think they get paid first, a few people think they get paid last. The majority of us think that they're listed as creditors, secured or unsecured in bankruptcy, and a few others think they lose their loans and probably friendship. What do you guys think?
They might definitely lose the friendships, that's for sure. See that often too. But the majority rules in this case, they're treated as creditors and they're treated the exact same way. Everybody shares proportionately if there is any recovery. A lot of times there's no recovery because the bankrupt individual has no assets. But what often happens also is someone says, well, I didn't include my brother on the list because I'm still going to pay them. And, you know, all creditors have to be treated equally. Practically speaking, if you pay your brother, your sister on the outside, nobody really knows. But the legal answer is all creditors are treated equal.
The biggest problem with having family there is, losing the relationship. The other problem is there's very little paperwork. It's done on a handshake. We need them to complete a proof of claim. We usually get a loan agreement, payment schedules, different things of that nature. And they're not very good at keeping that. So they may not have a loan agreement. They may not have a copy of the canceled check or money order that they gave, whatever it may have happened to be. So helping those people gather that information is what we do.
And we see that a lot. What happens if there is no information? What if you said, you know, I gave you $10,000 cash and a handshake and that was it? Are they done?
Well,
No.
I would have the person swear an affidavit
Yeah.
that says I gave the money on such and such a day, I paid cash. You know, if you can justify it even better by saying, well, you see, on January 5th, I took out $10,000 out of my bank account, that supports it. Usually that doesn't happen, but largely the trustee will only scrutinize these things if there's significant assets to distribute, or if, you know, the debtor says, no, that's not true, they didn't lend me that much money, but generally speaking, it's not fatal.
Thanks so much. Okay, why don't we move on to our next topic, legal fees and costs orders. So we talked a little bit about this in the question that came up earlier, but Howard, why don't you tell me a little bit about this section?
Sure. So legal fees we talked about. Those can still be paid post-bankruptcy because there's ongoing need for the lawyer's involvement. It's as simple as that. Post-bankruptcy, if you want bread, you have to pay Loblaws for the bread. Same thing, you want legal fees, you have to pay the lawyer for the legal fees. So that's not an issue. Cost orders pre-bankruptcy, those fall within the bankruptcy as regular creditors. So that you wouldn't necessarily have to pay. But again, as we talked earlier, there might be oppositions to your discharge. But generally doesn't happen because when there's a cost award, it falls within and people just accept it. Okay, they went bankrupt, I'm going to get nothing. And that's generally what happens. So to come back to a comment I made a lot earlier, is it's out of spite where people would oppose in these situations, because the debtor, the bankrupt, really has nothing to offer to pay. So we're beating a dead horse a little bit. But the question I often get asked is, what happens if a lawyer has money in trust, hasn't billed it, and then they find out their client went bankrupt? So technically speaking, money is in trust for the client. So technically speaking, that's an asset that would vest in the trustee. If I know that my client's going bankrupt, I bill it right before, just to make sure I don't have that problem. But if I didn't know that my client's going bankrupt, I would then, bill it, because you're holding the money. If anybody comes calling, unless we're talking hundreds of thousands of dollars, but if we're talking $5,000, $10,000, trustees don't generally go after professionals' fees. And they're not worth fighting over because the amounts aren't big enough. But, if they're bigger amounts, presumably the lawyer would have billed along the way. But if not, for whatever reason, then there's going to argue different quantum merit or unjust enrichment to the trustee if that was the case. So there are arguments to raise. So all is not lost for the legal profession when our client goes bankrupt.
I'm not sure I've seen a file where they've gone bankrupt or done a proposal just on cost awards. There's others debt that they've incurred along the way as well. So it's not just to get out of the cost award.
Thanks so much, guys. Okay. Last section, practice tips and strategies. This is the most fun one. This is what we're all waiting for with bated breath. I'm going to be typing really furiously. Barbara, do you want to start first?
Sure. Mine are rather quite simple. Like, do not co-sign for personal loans or vehicle loans for spouse, boyfriend, girlfriend, whatever it may happen to be. Keep separate bank accounts, have a house account that money goes into jointly, but keep it separate, and don't lend anyone money that you can't afford to lose. And if you're lending to family, it's a business transaction, not personal. Treat it that way.
So in response to all those points, much easier said than done. When your father-in-law comes to you and says, I'm about to lose my house if I don't make up the arrears on my mortgage of $20,000, and you come and, what are you going to do? So you lend.
I'm going to register on title.
Well, that's a good thing to do. Whether you pursue it or not is a different story, right. But at least you're protected.
Right.
But, I mean, if we want to be a little comical, you'd rather have the $20,000 loan out there as opposed to having the in-laws come live with you when they lose the house. So a lot of that is easier said than done. I just had a situation today where someone called me. They have a business loan. They didn't qualify on their own. So their best couple friends guaranteed the loan. And I don't know if the couple friends have any money, but the gentleman called me today and said, how do I get my friends out of this? I can't pay the loan. And so the company's going to go bankrupt. This gentleman and his wife, who are the owners of the company, have no assets. They live in a rented apartment and put everything they had into this condo, into this business. And their friends are going to get sued as well. So to Barb's point, do not co-sign for other people. This is the classic example where not only are you going to lose the friendship, but the friends are going to have a serious problem.
Yeah.
Now, the flip side is, well, I'm helping out my friends because otherwise they wouldn't have got the loan. They couldn't start this business. It was their dream business, but you need to understand the risks. And, with the father-in-law example, Barb had a very good suggestion that you register on title. But in this particular case, These people had nothing to offer as security. And even if they did, the bank is in first place over all the assets of the business. So if these people had a house, they could have registered as collateral mortgage to secure their guarantee. But if they had a house, the bank would have taken that too. So it's a difficult situation. So the other practical tip, which is also not a great tip, is it's really bad to be an unsecured creditor. Now, you can't help it, but banks can withstand those losses. They charge 22% interest on credit cards because they make up for the ones where they don't get paid. But individuals who lend money to their family and friends, you're most likely out all your money. So I guess if you're going to lend money to family and friends, operate under the assumption that you're never going to get it back. And so operate as if it's a gift. And if you get it back, that's a bonus. Anybody else have anything we could put in the chat if anybody has any other tips that they'd like to hear comments on?
I think that's just good life advice that you guys are giving. So thank you for that.
Well, we see it all the time. That's the problem. And then people get very upset when, well, I filed my proof of claim and I gave you all the paperwork and I supported my loan and I showed you my bank statement. So how come you're not getting me money? Well, because the bankrupt individual doesn't have any. So that's the real problem. So I think expect not to get it back.
Oh, in a bankruptcy, the return is very low. Proposals are far better for people.
If you had to guess, just for fun, what do you think that percentage is on bankruptcies?
On the personal side, I'd say probably about 5%.
Wow.
5% where there is a dividend.
Right. That's where there's a dividend and it's not just
Question
trustees'
is
fees.
also is how much is that dividend? So 5% where the trustee sends out checks, but it might be very small because that's all they could get. So in the typical situation of an individual, they might have a good job. So they might pay what's called surplus income. But what's surplus income? 20, 30, 40,000 because it's for a 21-month period. And we're not going to get into calculations of surplus income here, but take it as a given that it's a creation of the Bankruptcy Act. So $40,000, and assuming the person pays it, because often they don't, then you have the costs of administration, and then the person might have $1 million of creditors, and it's divided equally. So if you're splitting up $20,000 relative to $1 million of debt, the percentage is very, very low. So you might get a check, but it might not be worth going to the bank to cash.
Oh dear. What about consumer proposals? You said those are a little higher?
Consumer proposals usually have a better return. Can be anywhere from 10% to 100% in some cases, because the person can make that payment over time, or maybe they've come into an asset. There's ways in which that's written into the proposals, and proposals are far more common. Proposals have dividends that go out every 6 months or every year. Bankruptcies, dividends only go out when you close the file, and the trustee only gets paid when the file's closed as well.
So they're waiting a longer time as well.
So everybody's waiting a longer time. So yeah, consumer proposals are a better option if it's feasible.
Okay, wonderful. So we have a couple of questions come in. I'm sorry, I know we have a couple of minutes left. If the bankrupt spouse is the only one on title, is there recourse with the non-bankrupt spouse for unjust enrichment, constructive trust, anything like that? So sorry, unjust enrichment and constructive trust, that's a family law term, but if—
Yeah, no, we're familiar with that.
Okay, sorry, go ahead then.
I answered that individual as well, that those claims or those positions are often taken. So if those positions are not taken, it would be an equalization claim likely. But the trustee would then be possessed with or vested with the house and then go to sell it. So the non-bankrupt spouse would often argue constructive trust. I contributed to the household. The property was registered in his or her name for these reasons, but it was always intended to be both of our houses. And, I've seen a lot of cases where they go back and determine who paid for the groceries, who paid for the property taxes, to show or try to show that really there's a trust argument for a portion of the house, 50, 60, 70. I mean, they try to get as close to 100 in that case, because they'd rather have the asset as opposed to the trustee for the benefit of the creditors. So we see that a lot, and I actually hate those claims where you're counting pennies, because most of the time people don't have the records. Why do you keep the records of 10 years while you've owned this house? The Loblaws bills and came out of my bank account, his bank account, her bank account. It's painstaking detail that nobody has records for. So again, another reason to try to negotiate with the trustee in those situations.
Thank you so much, everyone.
Only ending point I would state is if you're negotiating equity of a home, and try to do it at the beginning and maybe get a court order, blessing of the creditor, something of that nature, major creditor. The trustee can always review it at the end of the bankruptcy. So if you're in a 3-4 year bankruptcy and prices went up like they did during COVID, and you're having to look at the equity again at the end of it and then renegotiate for the new amount, that can have a significant impact.
Thanks so much, guys. Okay, I see Shanza on. We've gone a few minutes over. I apologize, Shanza.
That's perfectly okay. This was very insightful. Thank you so much, Howard and Barbara. You are a wealth of knowledge. We look forward to learning and hearing more from you in the future. And I also want to thank our audience for sending all those questions in, and we try to get to as many as we can. Thank you so much again to our panelists.
Thank you.
Thank you, everyone.